Good morning, everyone. My name is Sterling Higa, Chairperson of the Authority. I'd now like to call to order the May 6, 2026 Kalaeloa Authority meeting of the Hawaii Community Development Authority. The time is now 11:27 a.m.
Thank you, Chair. In accordance with section 92-3.7 Hawaii Revised Statutes, the Hawaii Community Development Authority is holding today's Kalaeloa board meeting virtually on Zoom. The Zoom link details were included on the meeting agenda. Therefore, members of the public are welcome to join us on Zoom and also at our physical meeting site at the American Brewery Building, 547 Queen Street, second floor boardroom, Honolulu, Hawaii, 96813. The HCDA communication staff is hosting this meeting. Once this meeting begins, everyone will be muted for clear audio. Board members, if you have any questions or comments, please unmute yourself to speak. It is important that all individuals clearly state their name, pseudonym, or other identifier name each time prior to speaking. If you wish to provide oral testimony and you are attending virtually, please indicate so by clicking the raise hand button found on your Zoom screen. If you're attending in person, you'll be called to the front of the room in order to be signed up. Before you begin your testimony, we ask that you identify yourself and spell your name for the record. Your testimony must be related to an item on the agenda. All testimony will be limited to a maximum of 3 minutes. When time is elapsed, time will be called out, after which you will have 30 seconds to conclude your testimony, and then the audio will be turned off. If you're attending in person, the presiding officer will call the next testifier. Keep in mind that this is an opportunity to share your thoughts with us. If you ask questions during your testimony, neither the board nor the staff is required to provide an answer. If the authority's connection for the remote meeting is lost, the meeting will be recessed until the connection was restored. If the connection cannot be restored within 30 minutes, the meeting will be terminated and the authority will continue the meeting at another notice date. Thank you, Chair.
Thank you. HCDA board members remain visible and audible during the meeting. Also, please acknowledge you are present by either saying here or present. Let the record reflect that the following members are present. Vice Chair Ishii. Excused for now. Secretary Lidstone.
Ew.
Thank you. Member Miranda Johnson.
Here.
Thank you. Member Anderson.
Here.
Thank you. Member Evans.
Here.
Thank you. Member Strites is excused. Member Dubichel.
Here.
Thank you. And Member Gordner.
Here. Vice Chair.
Yeah. Oh.
Vice
Chair Ishii
Here
is present.
Okay, you have quorum.
Great. We have quorum. Thank you. For today's meeting, board members will have an opportunity to provide comments after an agenda item has been presented. Individuals from the public who have requested to provide verbal public testimony are on standby and will be permitted to testify respectively. Agenda item number 2 is the approval of minutes. These are the regular meeting minutes of April 1st, 2026. Board members, are there any comments or corrections to these minutes? Seeing none, the minutes are approved as presented. Agenda item number 3 is decision making. This is a request to approve the Kalaeloa Community Development District operating budget for the fiscal year 2026 through 2027 in the amount not to exceed $375,000 and authorize the issuance of land user assessments in the amount not to exceed $375,000 pursuant to Hawaii Revised Statutes 2026.05.06. Mr. Garrett Sasaki, Chief Financial Officer, will now present the staff report.
Thank you, Chair. Morning, board members. The staff report is in tab 2 of your packet. It is the standard request for approval of the operating budget for the Kalaeloa district. The amount is unchanged. The landowner table was updated to reflect current ownership. Open to any questions. Thank you.
Great. Thank you, members. Are there any questions or comments? Member Gordon.
Given the budget that just passed, either for this year or next, would be considering an increase in this in order to cover some of our costs? Would that be an option?
Next year, yes. For
Next
this year, it was too soon to react to that change.
Thank you, Member Gordon. Members, any other questions? Seeing none, we'll go to public testimony on this decision-making item. Are there any members of the public pre-signed up to provide testimony? Looks like we have 2 raising hands online to testify on this agenda item. So we'll begin with the first, which is Ms. Tara Rojas. Ms. Rojas, please confine your testimony to 3 minutes, please.
Okay. Aloha, can you hear me okay?
Yes, loud and clear.
Okay. So Tara Rojas for this budget item, uh, I want to say that the budget items here, and if you look on page 3 about the landowners, the fact that the foreign on the title, on the record, the title is just really not clear. So before you allocate any more monies for this HCDA plans, whether it's for the real estate plan, whether it's for the strategic plan, you cannot really build and lease, what is not yours without the true title. So I just want to put that on and for the record. So mahalo.
Thank you, Ms. Rojas. The next testifier is Avapuhi Kaluli. Sorry if I mispronounced your last name.
No, it's okay. My last name is Avapui Kalauli. And I'm actually testifying about the ownership as well. I'm also wanting to understand how to contest it. So my last name is Kalauli. There's 6 EISs that have been conducted in the Honouliuli Ahupua'a, and my family is a konohiki of the Ahupua'a from when you built the rail, from the taking over of Kalaeloa, and my family is also being targeted by the federal government as we are the landowners of Makua Valley, Kahanaha'iki. So I'm just kind of curious. We use this language of the land owners, but then we're requested to put in airship information, and it keeps being disheveled by every form of government, including this particular board, HCDA, as well as HHFDC. The state itself continues to ignore airship and title. And I am actually a royal patent title holder. The civil case number is 6539, 1992. It was reissued back to Kalauli. So I'm just curious because my family is in charge of 84 ahupua, including the Honouliuli, which comes down into West Lock. The waterway goes into Waihole, which is the Waihole ditch. And I'm trying to understand how we can continue to approve budgets, approve developments. And I did make a testimony to this particular board on March 5th of last year. I have been monitoring and watching the already contested case by Tara Rojas that you folks are trying to discredit because she's not Kanaka, but I am Kanaka and I am a Kalauli, and I would love to have an opportunity to contest the case, but I'm just confused as to how we are allowed to contest the case and she was able to. So I just want to put my testimony out there that I'm not just an heir, I am a landholder, I'm a title holder. And there is Hawaii Revised Statute 172-11 that states you're not allowed to challenge a land patent holder. And I am a land patent holder on 3 of my grandparents' side. So we have 3 royal patents. And I think that we should start acknowledging that. I'm not here to consult. I want to talk about the land ownership of my family. And that's my testimony.
Thank you, Ms. Kalali. We'll recognize Po'ohiva with their hands raised.
Please proceed.
Aloha. My name is Hiva Kahiaku Rodenhurst, and my husband is also here with me. His name is Po'okela Rodenhurst. And we also are coming forward to dispute the land ownership and as lineal heirs. And I also, as lineal heirs with royal patents and rights, titles, and interests to Honouliuli and other kuleana parcels within Honouliuli. The other thing that I do also want to state is that Tara Rojas has come forth on behalf of lineal heirs, including myself. And because of what Tara Rojas was, because she came forward and created the contested case hearing, me and my family were able to put in our or start consultation regarding our land titles and rights. And so I just want to make it very clear that, yes, Tara Rojas does also represent Kanaka Mo'oli's interests, and that she has brought us forward and that we are her witnesses. Therefore, her contested case needs to continue, and that yes, we are also disputing title and disputing land ownership as which is what you guys are discussing at this point. So sorry, I was kind of running to try and jump on this meeting. So just to be clear, we need to be consulted, or not just consulted, but we want to have a meeting, and we do want to put these owners that are coming forward on notice that the title that they may have or they think they have is actually there's fraud on the title. And so, yeah, how do we move forward and conduct this?
Thank you, Ms. Rodenhurst. We have one other person with their hands raised.
Yep.
Kekuanao Foundation should be able to unmute now.
Please proceed.
Or Kekuanawa, sorry. Okay.
They just need to unmute.
Kekuanawa Foundation, if you're able to, you should be able to press unmute and then you can testify. Okay, we'll move on, and then there is another agenda item, so if you wish to testify on that, you may.
Oh, hello.
Oh, sorry, go ahead. Yeah, we can hear you now.
Thank you
Yeah.
so
Go ahead.
much. Okay. Aloha, on behalf of Kekuanaoa Foundation, I am the lineal direct descendant of His Royal Highness Matayo Kekuanaoa. Aloha, Chair and members of HCDA. I stand in opposition to the proposed Kalaeloa budget. I speak as a konahiki with an inherited kuleana to care and manage the resources of this aina. My role is not symbolic. It is grounded in generational knowledge, stewardship, responsibility that continues today. Kalaeloa is not just land for development. It's an aina with ongoing cultural, historical, and resource-based relationships that must be respected. The core issue that this budget moves forward without recognizing my inherent rights and all the others who have come forward in the contested case that is, I'll be honest, it seems to be thwarted by concerted efforts of people within HCDA. And without due process of the law, the Kapa'akai analysis has been stalled and has been somewhat mitigated to non-existing. Because title is an issue, there's fraud upon the title. We, as the Ali'i families, the royal families, and the Konohiki families, we hold an interest to that. And I have come forward before. The Navy was willing to work with me, and then instantly it's HCDA. Without addressing the issue of title, we are actually putting all of our rights aside, which will cause a lawsuit against HCDA, because under the laws in which you function and operate, we're supposed to clear the title. And so I believe there's a parcel title history that was served upon HCDA that I would hope somewhere it would be entered on the record. But I am asserting my inherent right to be included in this process, not as an afterthought, but as a necessary voice in the decision-making process. This means early consultation, transparency, and the integration of my bloodline's knowledge and managerial practices as far as Kalaeloa and how it is planned and funded. HCDA has a responsibility to ensure its actions do not continue the pattern of excluding Konohiki families, royal families, and the Maka'ainana who also hold an interest. A budget that does not account for these rights risk harming both the Aina and the community connected to it. I urge you to reconsider this budget based on the fact that a true title parcel history needs to be conducted and considered as submitted as an independent researcher provided the parcel title history. Fraud has no statute of limitations. Thus, aside from this contested case that we are being swiped under and made to be invisible, is a direct contradiction of the codification that the Kapa'akai analysis stands for. And so let's not play these games of foreigner investments and rushing to solidify the budget from the Navy that is offering for the electrical infrastructure and to throw aside our inherent interests, because then that's a whole separate lawsuit that will come personally against the board because their failure
please
to uphold
summarize
their
your
own
testimony, please?
kuleana to work with the families. So in conclusion, please do your job diligently and responsibly. I have also made this testimony many of times before, and I would like my statement to be reflected in the record. Mahalo for your time. Aloha.
Thank you.
Thank you.
There's an iPhone raising their hand. I'm guessing it's a human and not a robot.
Aloha. My name is Cade Self. I'm an heir of Matayo Kikuano'o, His Highness, His Excellency. Do you guys know what is on royal patent? When royal patent is on private title, that's for private property. That's how we made that private property. So it could not be taken and used by one foreign entity. You guys got no right to be on it, doing any development, talking about money, about investing into these properties is not yours. It's private property. And your guys' U.S. Constitution, Fifth Amendment, you guys can't take private property. You guys can't turn it into public without due process and just compensation. There's a whole bunch of things. So let's not get there. Let's make things right. And the time is now. You guys got to stop. Stop touching stuff that's not yours. Private property is private property, and it ain't your guys' property to decide anything on. That's all. Aloha.
Thank you.
Thank you for your testimony. Anyone else present or online wishing to provide testimony?
Right. Okay.
Seeing none, we'll close public testimony. Members, any comments or questions related to this agenda item? Okay. There were two people there. So Ms. Kalaeloa, is this someone besides yourself who, because you already testified?
Yep, I actually wanted to ask you, because my son is also an heir and does have a right to testify, but he's 3 weeks old. So part of our royal patents is that heirship, it goes to Kanaka Apau, that includes the babies. So I was wondering if you guys had any consideration for our children. So his name is Hualalai Akaivi Kuamo Ke Kuokalani, E Papa Ipa Imai Kalalani, O Po Uli Uli, and he's 3 weeks old, and he is a Kalauli as well. And I'm wondering if you guys have any ways that you would get their testimony on these agenda items, as you know, he's 3 weeks old. And I just want to know what your standing of that is.
Sure. Ms. Kalaeloa, we allowed testimony from people who are able to provide testimony. And so if a 3-week-old were able to provide testimony, we would definitely accept it.
So he has to speak in order to be able to address these folks. Is that what you're saying to me?
No, people are welcome to submit testimony in writing, or if they wanted to do interpretive dance, they could do that as well.
So my 3-week-old has to also be able to write. Is that what you're saying to me?
No, I said that he could provide testimony in speech, in writing, or through sign language or other modes of communication.
Okay. Do you see how that's a problem? Because he's an heir to this property. He's a Kalauli. He's born. So do you see how that's a problem?
We've already allowed you to testify, Ms. Kalaeloa,
but I'm addressing an issue. I'm asking you, how do our children who are heirs to these properties be able to tell you their testimony when they cannot speak? And that's the problem. The problem is you have heirs that are not able to speak.
We're going to have to mute you. Okay. Members, any comments or questions on this item? Otherwise, I'm looking for a motion.
You need to figure this out, because he's a Kalauli and he. Yeah, exactly. I'm just gonna keep telling you the same thing.
Is there a motion for the board to approve the Kalaeloa Community Development Authority operating budget for the fiscal year 2026, 2027 in the amount not to exceed $375,000 and authorize the issuance of land user assessments in the amount not to exceed $375,000 pursuant to Hawaii Revised Statutes 206E-196? Members, do I hear such a motion?
So move.
Moved by Vice Chair Shi. Do I hear a second?
Second.
Seconded by Member Evans. Members, any further discussion on the motion moved by Vice Chair Ishii and seconded by Member Evans? If not, I'll ask Garrett to take the roll call vote.
Thank you, Chair. On that motion, Vice Chair Ishii,
Yes.
Member Evans,
Aye.
Secretary Lidstone,
Aye.
Member Miranda Johnson,
Yes.
Member Anderson,
Yes.
Member Dubachel,
Yes.
Member Gordner,
Yes.
Chair Higa.
Yes.
Thank you. So motion passes with 8 yeses,
And one excuse.
1 excused.
Thank you. We'll move down to the next agenda item, which is going to be deferred. That agenda item was, shall the authority adopt hearing officer Rodney K.F. Ching's findings of fact, conclusions of law, and recommended order in the contested case dated April 22nd, 2026 in the matter of Tower Rojas versus Hawaii Community Development Authority CCH 2025-001. But we will defer that agenda item to a later notice date. The next agenda item is the report of the executive director. This is the monthly and other status reports, including approved permit applications that did not require HRS 206E-5.6 public hearings. Executive Director Nakamoto will now provide his monthly report.
Thank you, Chair. I'll keep it short. Just want to highlight under Roman 2 capital improvement projects. Our capital improvements team has done a great job in getting the IFB for the Saratoga electrical infrastructure work posted. This is the from the funds that we got from the legislature in the amount of about 12.125 million. The bids are due May 26, 2026. So more to come. That's one of 3 electrical projects that are going on in the district. Thank you.
Thank you. Members, any questions or comments? Member Evans.
Chair, may I ask, Executive Director Nakamoto, what is zoning clearance?
Zoning clearance is a type of permit. Zoning, so we have several permits that don't require like a PDP, and zoning clearance is kind of a lesser permit. Is administrative.
And is it a clearance or what is it?
Go ahead.
Member Evans, just to clarify, the zoning clearance is a approval or it's a confirmation that we provide to the Liquor Commission or to the ATF. So it has to do with verifying that the land uses are allowed or liquor licenses. Also, there's a fire.
All right. Thank you very much. I appreciate the explanation.
Good question. Members, any other comments or questions on this agenda item? Member Gorger.
Do we have any bids yet for the IFB, or has there been like a pre-bid workshop with attendees, or just some indication that we will have some
I think
respondents?
I think we will.
Okay.
So it's May 26th.
Okay.
Thank you, Member Gordner. Members, any other comments or questions? Seeing none, we will open public testimony. Do we have any persons pre-signed up to provide testimony? Looks like we do have some people online wishing to provide testimony. So please identify yourself, limit your testimony to 3 minutes each, and clearly state your name, pseudonym, or other identifier name for any organization you're representing. The first person raising their hand to provide testimony is Tara Rojas.
Okay, this is Tara Rojas, and I have a question. I just heard you guys said we gotta figure out if the land use is allowed. So With that, and with the testimony you heard from the previous item, I would say that no. And talk is regarding land use, for and on the record, I would like to say that I'm still waiting for a response regarding what I had just turned in on May 3rd, the motion for exception, and which was agenda item number 2 as well. And so we're waiting on that. I know it's going to come up June meeting. And if I could ask for clarification, what is this meeting you guys are talking about that is going to be on May 26th? At what time? Is it under the Kalaeloa board meeting? Is it a special meeting? Where shall we find that? Because when I was waiting to see when the agenda for this meeting will come out, it wasn't 6 days before. So I don't know exactly what day you put it up, but it was like you had to be there just a few days before. Is that going to be the same process for the May 26th? So again, what time is that May 26th meeting, the title of it, and where can we find it and find out the agenda for it? Mahalo.
Ms. Rojas, I direct you to the HCDA website where all meeting agendas, minutes, and recordings are posted. Next testifier is, who is it?
Kikuana Foundation.
Kekuano Foundation. Go ahead.
Okay, here we go. Can you hear me? Just making sure.
Yep.
Okay, great. Again, here, same issue on the table. I submit this testimony in strong opposition to any action advancing the Kalaeloa budget or related development analysis and a firm assertion of my equitable and inherent rights as a Konahiki over these lands. As a Konahiki, my kuleana to Kalaeloa is rooted in generational stewardship, resource management, and an enduring.
Just so you know,
this responsibility is, again, not symbolic. It carries with it equitable.
Sorry, you're sort of cutting in and out. So if you're like on a cell phone, if you move to somewhere where there's stronger signal.
Okay, I'd like to take my time back for that.
Yeah, please restart. We want to make sure we get your testimony.
Okay, yeah, because I definitely want it on the record. So, staying in the same continuity as previously stated, as Konahiki, my kuleana to Kalaeloa is rooted in generational stewardship, resource management, and an enduring relationship with this aina. It's not symbolic. It carries with it an equitable interest and authority tied to the care, access, and sustainable use of natural and cultural resources. These rights persist and must be meaningfully considered in any state action affecting this area. HCDA's proposed course of action raises serious constitutional and legal concerns. The state of Hawaii has an affirmative obligation to protect Hawaiian traditional and customary rights under Article 12, Section 7 of the Hawaii State Constitution. This duty is not discretionary. It requires agencies to actively identify, assess, and protect these rights prior to taking action. The Hawaii Supreme Court in Kapa'akai Oka'aina versus Land Use Commission established a clear three-part framework that agencies must follow. Identify the additional and customary Native Hawaiian practices and exercises in the affected areas, determine the extent to which those practices will be impacted by the proposed action, and specify feasible actions to reasonably protect of those rights. Advancing decisions without completing this analysis constitutes a failure to meet these legal requirements. Further cases, such as Public Access Shoreline Hawaii versus Hawaii County Planning Commission and Kalipi versus Hawaiian Trust Company, it reaffirms Hawaiian rights, including access, gathering, and resource management. It must be preserved and protected. Ignoring the need for a kapa'akai analysis risks unlawfully impairing these rights. I therefore assert that my equitable and inherent rights as a Konahiki require meaningful and early consultation, full transparency in decision-making, and the integration of Hawaiian knowledge systems into planning and budget process. Failure to complete the kapa'akai analysis prior to action not only violates the established legal standards, but perpetuates the ongoing marginalization of Hawaiian stewardship and authority. I urge HCDA to halt any advancement of the Kalaeloa budget and related actions until a full and proper kapa'akai analysis is conducted, and to commit a process that genuinely recognizes and protects Native Kanaka Maoli rights. Mahalo for this opportunity to provide my testimony. Aloha.
Thank you. We'll move to the next person, which is Avapuhi Kalaeloa, for testimony not to exceed 3 minutes, please.
So my name is Avapui Kalaeloa, and I'm testifying on behalf of Kualalai Kumu Kalaeloa and myself together because since he cannot speak, he's 3 weeks old. It's very heartbreaking. Honestly, it's heartbreaking that in 2026, Hawaiians are continue to be considered the wayside and ignored, and ignorantly our titles are ignored because we have no standing here. We live in a land that is developed by foreign entities, not by Hawaiian entities. And we have to continue to make testimonies because nobody is listening to us. And I have 39 acres of untaxed land in the Big Island. A cousin who's a very well-known singer lives on that property. Imagine what I would do with 39 acres of untaxable land for developers. I think I should start developing our properties and see what happens, what kind of sweetheart deals Hawaiians can provide to these foreign entities. I really think that it's time that Hawaiians are not ignored. We need to be considered. And that's my testimony. And that includes the babies, they're heirs. And that's why I brought it up. You might think it's funny, but they are heirs. They are included. And he's born. He might be 3 weeks old. He can't make a speech unless you can have an interpreter to, announce him, then that's fine. But ultimately, Hawaiians, like, at what point are we going to change the message here in Hawaii that Hawaiians need to be in Hawaii, not on planes, not on the mainland, not in other areas like here? And I hope that we address that one day. I hope that that becomes a sentiment that we all can agree upon.
Thank you for your testimony. The next person is Ho'ohiva.
Okay, my name is Hiva Kaheaku Rodenhurst, and I'm also here on behalf of my husband, Po'okela Rodenhurst. I submit this testimony in strong opposition to any approval, continuation, expansion, permitting, or advancement of electrical infrastructure and related development activities within the Kalaeloa and Honouliuli areas while there remains an active contested case proceeding concerning titles, cultural rights, and the legality of development actions affecting these lands. At this very meeting, the board is considering right before this, right? Actions connected to a contested case identified as case 2025-001 in the matters of Tara Rojas versus the HCDA board. The existence of this contested case itself demonstrates that substantial unresolved disputes remain before the agencies regarding the lands, cultural impacts, and lineal descendant concerns, consultation failures, and the legality of HCDA's actions. Proceeding with any electrical infrastructure, construction, approvals, easements, trenching, utility expansions, and related land disturbance, while these issues remain unresolved, create irreparable harms and risk prejudicing the rights of parties and effective descendants before a final agency determination and judicial review process is completed. The lands of Honouliuli and Kalaeloa are not vacant or culturally empty lands. Numerous lineal descendants, Konehiki descendants, and Kanakamori families have already come forward, asserting ongoing interests, traditional and customary rights, cultural connections, burial concerns, and claims relating to historical titles and occupancies. And these rights, as we said before, are being blocked by HCDA because we are not being allowed to continue in our kapa'akai analysis. Therefore, this is why the contested case needs to continue, and our preliminary report on the title has been provided to the department. So I don't understand why you guys are continue with this board meeting, making these decisions when we have this issue that's still pending. These issues are not hypothetical. They're actively being raised and contested in this process. Allowing infrastructure expansion during periods of litigation and contested case proceedings undermines the public trust and creates the appearance that HCDA has predetermined this outcome before the contested case process is completed. Such actions risk rendering the contested case meaningless. It develops legal and factual disputes that, as we're saying today, are unresolved. So you guys shouldn't be moving forward with anything. Additionally, the HCDA has also constitutional and statutory obligations to protect Hawaiian traditional and customary rights, including obligations recognized under Article 12, Section 7 of the Hawaii Constitution, as well as duties under the Kapa'akai analysis, jurisprudence requiring meaningful identification and protection of cultural practice, resources, and our land rights. So therefore, what I'm asking is to defer or deny any approvals related to electrical infrastructure, utility expansion within Kalaeloa until our contested cases are fully resolved. And we preserve our rights as Kanaka Mo'oli nationals, even though we're participating in this process.
Thank you, Mrs. Rodenhurst. Is there anyone else wishing to provide testimony? Maleka Hicks.
Hi, aloha. Can you guys hear me okay?
Yes, loud and clear.
Okay, yeah. So I also would like to call a contested case because there are actually there are a lot of historical sites and also burial sites, as well as descendants who have civil claims ties to that aina. And I just want to state on the record that HCDA denied the Kapa'akai analysis with Ulupoa. And I was one of the people who were consulting with Ulupoa on behalf of the Kapa'akai analysis. So I just want to say on the record that this is a restriction of our voices to be heard. And once again, I would like to call a contested case with HCDA in regards to the Kalaeloa master plan. That is all, Mahalo.
Thank you for your testimony, Mr. Hicks. Is there anyone else wishing to testify? No. Seeing none, we will close public testimony. Members, any questions or comments before we adjourn for the day? All right, seeing none, members of the public and staff, thank you for your time today. That concludes our business. The meeting is adjourned. The time is now 12:05 p.m. Thank you, members.